All right, everyone. Good morning. It is now 11 o'clock. Can everyone hear me okay? You can use that chat feature that you found at the top of your screen. It looks like a little thought bubble. Okay, great. I have a couple people already chiming in, so wonderful. So first, good morning, everyone, and welcome to HireMojo's webinar, Laws, Wages, and Fines. Oh my. The shocking employment laws that could cost you a fortune in 2017. We would like to thank you all for your time today. Okay, so before Shane and John kick it off, we just wanted to make sure everything's working properly. It sounds like everyone's able to hear us as well as see John's screen. And now that everyone knows where the chat feature is located, if you haven't already, top of your screen looks like a little thought bubble. And this is going to be where you're going to be submitting your questions as well. And Shane and John will be addressing questions at the end of the webinar. So then, now that I have the technical stuff out of the way, I have the pleasure of introducing your host, John Younger, CEO and founder of HireMojo. John's current focus with HireMojo is delivering a hiring automation platform that addresses the social issues of having millions of jobs go unfulfilled for too long. In the United States today, there are over 5 million open jobs, with roughly half of them open 90 days or longer. And this is a profound social issue that, when improved, will positively change the lives of the people filling them and the success of companies with the openings. And I would also like to introduce our guest speaker for today's webinar, Shane Cahill. Shane, thank you so much for joining us as well. And Shane is Senior Counsel with Long & Levit. His practice focuses on counseling and defending California employers, large and small. He is an experienced trial lawyer with broad civil litigation experiences. Shane also counsels employers on employment policies and practices, avoiding harassment and discrimination claims, compliance with California's wage and labor laws, and other day-to-day legal issues. So with that, I would like to send it off over to Shane and John to take it over from here and present some great stuff for you guys today. Thank you.
Thank you, Nicole. Hey, a quick check here. I see Laura May saying that there is no audio, although Andy said you can hear it, but there's an echo. There's still an echo, Andy? Or is it better? And Laura May, if you need to, you can call in. On the screen, you can see that there's a little phone icon on the upper left. Worst case, you can dial into that number, and that should connect you to the audio, not through the computer if that's an issue. So if someone could let me know, is the echo now gone? Hopefully it is, and we can proceed.
John, this is Shane, and I'm not hearing any echo, so.
All right. You may want to talk a little bit louder, Shane, if you can.
Sure,
Yeah.
No problem.
All right, well, let's go ahead and proceed. This has been a banner year, hasn't it, Shane, in terms of changes coming down?
It really has. Legislation-wise, this was actually a fairly light year. Generally, California always has a robust number of employment laws that they enact from year to year. This year wasn't too heavy, but there were some significant laws that were enacted or amended this year, as well as some important court cases that employers should definitely be aware of. I'd be happy.
And what are the ones that are like top of mind for you?
Pardon me?
And which ones do you think are top of mind for you and you think are the most meaningful, just kind of kicking this right off?
Sure. So I think one of the most significant new laws that employers in California should be aware of is the California Fair Pay Act. And it's not necessarily new in that California was one of the first states in the 1940s to enact an equal pay law to prevent gender-based pay disparities. However, in 2015, the law was amended quite significantly because the legislature found that there were still gender-based pay disparities despite the laws that had been in effect for decades. This year, so what happened in 2015 was a few things occurred to amend the equal pay law, and under the old equal pay law, employers were prohibited from paying employees of different genders different wages if they were performing the same jobs. It was basically equal pay for equal work. In 2015, the law was amended so that now employers have to pay employees equal pay for substantially similar work, and that's an important and very significant difference. This year, the law was expanded even further to prohibit wage disparities based on race or ethnicity. So now California's Equal Pay Act applies both to gender-based pay disparities as well as pay disparities that are based on race or ethnicity. So employers really have to pay attention to how they're compensating employees and ensure that employees who are doing substantially similar work, even at different locations now, are being paid equally.
Shane, isn't that something that's always been there really since, you know, some of the laws that went in 1965, of course, and several of the others that have come through since then? What's new about this one's different than previous laws that address the same topic?
So what changed with California's equal pay law, there were really two significant amendments. Under the old Equal Pay Act, employers had to pay employees equal pay for equal work. And court cases, judges and courts of appeal took that quite literally. So, for example, let's just take a hotel setting. If you had room attendants, all room attendants, regardless of gender, had to had the same wage. They had to be paid equally. A room attendant might not have to be paid the same wages as, say, a handyman. In 2015, the law was amended so that employers now have to pay employees equal pay for substantially similar work. And a common example, again, in this hotel context was, well, now instead of just looking at ensuring room attendants are paid equal wages, they have to really look at the job description, what the employee is doing. And a room attendant may be doing very similar things as a handyman. They're cleaning, taking care of rooms, ensuring a good guest experience. And so those employees, insofar as they're doing similar work, have to be paid equally. And that really shakes up the case law because there's no clear definition at this point as to what entails substantially similar work. Another big change to the Fair Pay Act was that employers now are required to ensure equal pay among all their work locations. Under the old law, employees in San Francisco didn't necessarily have to be paid the same wages as, for example, employees at a work location in Sacramento. The new amendments eliminated that. Now there's still
but
that
sounds frightening.
It is frightening.
So,
and that was
just to put it in context.
Concern.
Just to put it in context, does that mean that somebody who's in Chicago now will be forced to be paid the same as someone in San Francisco?
It's definitely a possibility. Now, there are exceptions to the law, and there are exceptions based on business justification, and so there doesn't necessarily have to be perfect equality, but the burden falls squarely on the employer now to justify the pay disparity and explain why an employee in Chicago is making more or less than an employee in San Francisco. And that burden is not an insignificant one. If the cost of living is substantially different, that might be enough to pass the test. But, for example, in Chicago and San Francisco, rents are high, and so you might need a little bit more to justify the pay disparity. So those were two very big and significant changes to the law that employers should be very aware of and should be looking at what their workforce is being paid to ensure that there's no inequity there.
And what do you see in terms of claims then as it relates to this?
Well, right now, just given that the law was only recently amended, we've not seen any civil lawsuits. However, there are cases that I'm aware of where the government is looking into this. There's a big pending action from the Office of Federal Contract Compliance against Google, for example, where they're embroiled in administrative litigation over production of literally millions of data points of information from Google to determine whether Google's roughly 19,000 employees are being paid equal pay for substantially similar work. So this did gain the attention. These amendments did gain the attention of at least the U.S. Department of Labor, and it's just a matter of time before we see the plaintiffs' bar start to pursue these claims and really look into it. Another significant amendment to the Fair Pay Act was a provision, an express provision, stating that employers cannot prohibit employees from discussing their pay. And as this gains more media attention, inevitably employees will be talking about what they earn and whether they're earning similar wages or salary, and if they find disparities, undoubtedly they will go seek the advice of counsel, and that most probably would turn into a claim or some form of litigation.
So does this start with misclassification, or what's at the where should a company start to look at this?
Well, the Fair Pay Act and the classification of employees don't necessarily go hand in hand. In terms of looking at just equal pay, I think where a company starts is looking at its job descriptions and evaluating whether employees who are doing substantially similar work are earning equal pay. From a classification front, the Equal Pay Act applies to exempt and non-exempt employees, whether you're salaried or you're earning an hourly wage. Now, if a business hires an independent contractor, for example, the Equal or the Fair Pay Act would not apply to an independent contractor. So that form of classification could be important. If someone is a bona fide independent contractor, is not an employee, many of California's labor laws just don't apply to that person. So what we've definitely seen in recent years, especially in the so-called gig economy, is businesses deciding to classify its workforce as independent contractors, purporting to give them a certain level of freedom in terms of selecting hours and the method and manner in which they complete their work in order to, in some cases, try to avoid what are fairly harsh labor laws in California, or what can be, if violated, very harsh penalties for employers. But those classifications, if not done properly, can have quite dire consequences.
I'm still confused, because when I think of the drivers that I've certainly used with Uber and Lyft, they work for Uber, they work for Lyft, they work for another employee who's a part-time employee. In some ways, that sort of is the epitome of the independent contractor, although it looks like they're, as we all have been reading, been targeted as misclassified as contractors. Can you add a little more meat to that? Because it seems like I said, that's almost the quintessential definition of a contractor.
Yeah, the two most recent and probably high-profile examples of these misclassification cases, and I've seen it in a variety of other contexts that we've had to litigate, have been in the Uber and Lyft lawsuits. Those have gained a lot of publicity. They involve tens and if not hundreds of thousands of employees. The position of Uber and Lyft was that they entered into agreements with these drivers, and under the agreements, the drivers could work for competing companies. They could select the times that they wanted to work, and they weren't controlled in terms of the routes they would take or the manner in which they would perform their job. The plaintiffs in those cases alleged that, yes, while we may have been classified in an agreement as a contractor, and while, yes, we may have on some level been able to choose our own hours, ultimately these companies had the significant right to control the manner and means in which we worked. And that really is the test. That is the linchpin. That's the key to determining whether someone is an employee or an independent contractor. And there are a lot of other factors that federal and state courts, and test is a little different depending where you're at, but there are a lot of other factors that you can see are relevant. But really, the right to control is the factor. And what the Uber and Lyft plaintiffs claimed was that through the app and through the company's ability to, get the company's ability to shut down the app for poor complaints, that there was a significant right to control, even if it wasn't always exercised. And, there was never a decision on the merits in the Lyft lawsuit. That case ended up settling recently for $27 million, and that was after a federal court judge rejected a $12 million settlement. So you can see the consequences of a misclassification, even when the plaintiffs don't prevail, just by simply bringing the lawsuit. The penalties for misclassification are so substantial that these cases often settle before there's ever even a determination. So those are two kind of extreme situations, but I've seen misclassification cases in the hospitality industry, at restaurants, with managers at small businesses. So these cases, employers really do have to pay attention and make sure that they're properly classifying their workforce.
So are the drivers for Uber and Lyft now considered and on contract as employees for those organizations?
So they actually are not. The Uber case is still pending. The Lyft case settled, and there was no provision in that settlement that required Lyft to reclassify its drivers. And that's usually the case in these misclassification lawsuits. In most situations, you don't have an agreement between the parties where the workforce is reclassified as employees and where the employer then has to begin paying minimum wage along with the other protections afforded employees under the labor code. Now, I have recently been involved in cases where, as part of the settlement, we did agree to reclassify workforces, but that's definitely the exception and not the rule. Now, it may be different if these businesses decided to take the case to trial and get a determination on the merits, get a judgment or verdict from a jury. But in most cases, that's not where it goes. The vast majority of these settle outside of court without a reclassification.
So just so I'm clear, the suit was about the misclassification of the drivers, and I use this because I think it'll be helpful for all the companies on the call. because many companies use contractors. I know Google uses a tremendously large number of contractors, where one could argue the amount of control exerted exceeds that by Uber or Lyft. But here, the lawsuit came forward about misclassification. Lyft, in this case, settled, but no one was reclassified. So might the conclusion one could draw be that they weren't, in fact, misclassified, but they were just simply a really big target?
That's definitely the case, and in fact, in approving the settlement in Lyft, which again was very substantial, the judge who wrote the opinion allowing that settlement to go forward specifically stated that it was a difficult question, and he specifically wrote, how to classify Lyft drivers under California's archaic law is a difficult question, and it did not seem that Lyft made its initial classification decision in bad faith. And that's an important note, because especially in this gig economy, more and more companies are going towards the independent contractor classification. So that just because a lawsuit happens doesn't mean the employer is wrong. But the lessons from Lyft and Uber is that when you decide as a business to classify employees as independent contractors, especially if you have a large workforce, is to some extent you become a target. You become a target for plaintiffs, class action lawyers like the ones in Lyft and Uber, who see it as an opportunity to make a big splash in the law and obviously a very large payday. And you become a target from employees who may not perform well as independent contractors. They may have contracts terminated, and then they go and seek the advice of plaintiffs' lawyers because at the end of the day they were paid less than minimum wage because they were poor performers. So those, I think, are the big lessons to learn from Uber and Lyft and cases like that, is even if you're not wrong as a business in how you classify employees, and courts have expressed this time and again, it doesn't make you immune from a lawsuit, which is obviously incredibly expensive to defend. And in Lyft's case, they decided it was worth a $27 million settlement rather than going to trial and getting an actual determination on those merits. And again, I see that more often than not in these misclassification cases.
Thank you, Shane. That really helps clarify some things. And I have to ask one last question about Lyft specifically, and then we'll move on. And that is, as an HR leader, as a business leader, I find that following the money can be incredibly illuminating. So where did the $27 million go once that settlement was paid? Who received it?
Yeah, so the Lyft settlement, if I'm recalling correctly, was what's known as a claims-made settlement. So Lyft drivers, after the settlement was approved by the court, would receive notices in the mail that there was a settlement of a class action lawsuit, and then they would have to submit a claim, and based on the number of hours they drove or miles or expenses they incurred, the settlement they would receive varied. And I don't recall the amounts, but generally in these cases, the settlement portion that actually goes to the members of the class, that is the Lyft drivers or the employees who allege they've been misclassified, it can range from hundreds of dollars to a couple $1,000. Rarely do you see class action settlements where employees are receiving more than $10,000, $20,000. So it's usually a fairly small amount per person, but on a grand scale, it amounts to a $27 million settlement. Of course, the plaintiff's attorney in the case gets a substantial fee. All labor code lawsuits generally involve claims for attorney's fees, and in most cases, the plaintiffs are entitled to recover their attorney's fees. And in settlement, certainly that's something that the court wants to see. And I believe the attorneys in the Lyft case received about 25% of the $27 million settlement. So it's a very large payday for the plaintiff's attorney who prosecuted the case.
So they got,
which of course drives cases and motivates
$7 million.
Yeah.
Yeah, because the reason I ask, and I'll share this with the group, because I've been on the other side of the class action where I had nothing to do with it with a bank, and I got a check for like $8. But I'm sure the attorney's got several million.
Correct. That happens many times, and especially when you have a very large workforce. I mean, if you have a class action involving a couple hundred employees, usually the amount per employee is much higher, but there's generally always an imbalance between what any individual is, well, there's certainly an imbalance between what the individual is receiving and what the attorney prosecuting the action is receiving, but even in terms of what the whole class is receiving and what the attorney receives, there's generally an imbalance there. So these cases, plaintiffs' lawyers look for them. They can be quite lucrative. And again, these were cases where the plaintiff's attorney didn't even necessarily prevail. They just knew that the cost of litigating and the consequences of Lyft losing the lawsuit were so great that it was likely going to drive towards a settlement. Particularly in California, we have what's called the Private Attorney General Act that allows employees to sue businesses for labor code violations and recover penalties that normally only the state of California would be able to recover. And these lawsuits have really taken off in the last couple of years, in part because a lot of businesses were starting to use arbitration agreements and including class action waivers in their arbitration agreements. And we've litigated this quite extensively in both federal and state court in California. And in 2014, the Supreme Court in California, based on decisions it had previously issued being overruled by the United States Supreme Court, had to concede that class action waivers in arbitration agreements were valid in California. And that was a big victory for businesses, because with that, it could cut off these large class actions like Uber and Lyft. However, under the Private Attorney General Act, the California Supreme Court decided that you could not force employees to waive their rights to bring a claim on behalf of themselves and the whole workforce. So even though employees in California can't necessarily bring class actions, if there's a valid and enforceable arbitration agreement with a class action waiver, they can still bring what's known as a representative action to seek penalties against businesses. And in a class action, employees may also seek penalties, but they would also be seeking their back wages, unpaid overtime, unpaid expenses, things like that. In a PAGA action or a private attorney general action, they would just be seeking penalties, but the penalties for independent contractor and misclassification cases can range from $5,000 per instance of misclassification to $25,000. So they're significant penalties, and even those lawsuits pose substantial risk to employers. And so employers should just be aware that when they decide to classify their workforce as independent contractors or a portion of their workforce as independent contractors, that there are some risks there. Even if they're right, there are risks of getting sued and not being able to cut off a large class action type lawsuit.
Got it. So the takeaway for me was it may be advisable for an employer, if you do have a large contract workforce, to put in some kind of a clause in there about the class action. While it isn't going to stop everything, it might help slow things down. Is that fair?
Most definitely. Most definitely.
And let's switch
and
now,
you definitely
Shane.
want to consult with someone that has experience writing arbitration agreements and really knows the lay of the land with respect to how the law has developed over the last year. There's still battles going even today through the Supreme Court over the validity of arbitration agreements and class action waivers, and so that's very much a evolving area of the law. So an arbitration agreement that an employer might have from, say, 2 or 3 years ago may no longer contain the right language. The law has just changed, and next year they may need to be updated again.
Got it. Let me switch now to something that I think most people on the call and certainly most employers know and know well, called exempt employees. What specifically has changed or is changing in 2017 as it relates to exempt employees?
You know, there aren't a lot of significant changes regarding exempt employees and the definition of which employees qualify as exempt versus non-exempt. There were some minor revisions to the labor code about the information that must be contained on the pay stubs for exempt employees, and namely whether information regarding the number of hours exempt employees work needed to be on pay stubs. And the legislature decided that if an employee is properly classified as exempt, employers don't need to include information regarding the number of hours that that employee works during the pay period on his or her pay stub. And that's somewhat of a significant change in the law, because in the last several years we've seen a lot of wage and hour lawsuits filed that allege pay stub violations. It's kind of an easy claim that we see plaintiffs' lawyers tack on to other type of wage and hour violations, and it can carry not inconsequential penalties if pay stubs aren't accurate or they don't contain all the information that they need to have. So the law was relaxed a little bit this year with regard to pay stubs for exempt employees, but the classifications largely remain unchanged and the same. And that's another area where employers just need to be careful with respect to who they classify as exempt, because once that classification is made, the employee is no longer entitled to overtime pay mainly, and if the employer is wrong on that, there could be a significant claim for unpaid wages and even penalties.
And what do you see in line with exempt employees, this idea of unlimited paid time off and things like the Netflix culture, where on one hand, I think many of the employees, certainly in California, are moving more toward this more free or open sort of work engagement as an exempt employee, and the government seems to want to have it more controlled and tracked and hourly and overtime. Is that an accurate assessment of the dynamic?
You know, to some extent, yes. A lot of employers want to classify, especially what they view as management-type employees, as exempt. They view them as executive employees or administrative employees that fall within one of those exemptions. Towards the end of the Obama administration, there were efforts made to create tighter laws around overtime pay, and I think that started driving employers to seek this exemption and fit employees into one of the exemptions so they didn't have to pay overtime. With the election results falling the way they did, the Trump administration has already started to roll back some of these overtime regulations. For businesses that operate outside of California, It's probably more significant than businesses that operate within California, because California's overtime laws are already fairly strict. If an employee works over 8 hours in a day and or 40 hours in a week, he or she is entitled to overtime unless they qualify as an exempt employee. So the government was really pushing that towards the end of the Obama administration, but things are changing, of course, just given the election and Trump's pro-business stance. We'll see how that plays out, but that's where things kind of stand now. But even without government involvement, employees can still make private claims for being misclassified as exempt, and we've handled those. They can file civil lawsuits. They can make complaints before the Department of or the Division of Labor Standards Enforcement, and those can be very hard to defend unless the exemption clearly applies. And for the exemptions to apply, you obviously have to meet the salary requirements. An employee to be exempt has to be paid at least twice the state minimum wage for full-time employment. So in California, with the $10.50 minimum wage, that employee would effectively have to be paid $3,640 per month. That's just the salary component. And then depending on what type of exemption they're classified as, courts or the Division of Labor Standard Enforcement will look as to what the employee's primary duties are. For the executive exemption, for example, that really only applies if the employee is spending at least half of his or her time managing the business and directing the work of at least 2 other employees. And I've had to defend these. I've had cases where we've had managers at hotels who were setting the schedules of 2 employees who would direct the work of those employees and to whom those employees would report. But nonetheless, the DLSE, who is really there to help advocate on behalf of the employees, found that this person did not engage in that type of activity during at least 50% of his day. So the ruling from the DLSE was that he had been misclassified as an exempt employee when he really should have been classified as a non-exempt hourly employee. And that in and of itself isn't necessarily significant. But because he had been classified as exempt, the business was not keeping track of his hours. He didn't have to clock in. He didn't have to clock out. So at the hearing, he basically came forward with a summary and an estimate of the number of overtime hours he had worked. And under California law, the employee is basically entitled to the benefit of the doubt that his or her estimate of the hours they worked is accurate, and it's on the employer then to rebut or beat back that presumption and say, no, we've got records showing the number of hours he actually worked, and he didn't really work much overtime. Well, because he had been exempt, classified as exempt, the employer didn't keep track of that, and they couldn't rebut his presumption. They ended up having to pay a fairly significant sum to resolve the dispute.
Well, this is particularly interesting when thought about in terms of reclassifying. So let's say as an employer, I've got someone that is currently classified exempt, and after this webinar, I'm sufficiently terrified that it's going to be misclassified. And I decide to then change the classification to non-exempt. Does that in and of itself expose an organization to having that employee come back and say, that's great, I'm now non-exempt, but guess what? You owe me all these back wages for overtime.
It most definitely can. And we've worked with businesses to deal with those situations, different firms who ultimately we came to the conclusion on their behalf that they had misclassified a workforce as exempt employees when they truly should have been hourly employees. And we had to develop strategies to help the company reclassify its workforce while minimizing and mitigating the risk that the employee will then come back and file a claim, because these wage claims can go back as far as 3 or 4 years. The statute of limitations is significant. And there are strategies for dealing with that, including explaining to the, depending on the timing of when that decision is made, if it's at the beginning of the year, in conjunction with issuing a new employee handbook and explaining to employees that the company's very interested in creating a good work-life balance and providing vacation pay, and instead of salary and having to work all these overtime hours, explaining to the workforce that they'd rather have employees working that number of hours and being paid more for overtime wages. So there are ways to deal with those, but it is a challenge, and you're right, it can definitely be a red flag for employees who then realize that maybe this is happening because I was misclassified. So again, the lesson is try to make the right decision up front so you don't have to change the practice down the line. And then when you do, I think it's really wise to consult with somebody and not just make a sudden, inexplicable change, but to do it as part of a bigger process of almost changing the culture of the business.
Got it.
Or at least
well, let's switch now. Let's switch now to hiring practices and interviewing and what you see coming in 2017.
So hiring practices and interviewing pitfalls. I mean, I think this is something that obviously pertains to all businesses, and as you guys are definitely part of the hiring practice, it's something that I'm sure you have a lot of interest in. We get a lot of questions on the counseling front just about what are appropriate and inappropriate inquiries during pre-employment screening and interviews. And I think the overarching answer to that is, as long as the inquiry and questioning is job-related, it's going to be permissible. Where employers and businesses start running into problems is when they start looking at what are known as non-bona fide factors to make hiring decisions. And that could be looking at an applicant's age or race or gender or pregnancy, and making hiring decisions on that basis, or even firing decisions. It might sound ridiculous in this day and age to say it, but by far we see more and more lawsuits about age discrimination or gender discrimination than any type of wage and hour lawsuits or violations. They're by far the most prevalent. I think we had a slide earlier on. We don't need to go back to that. But every year, the number of claims that employees make to the Department of Fair Employment and Housing, the DFEH, the body in California that really regulates discrimination and harassment claims, every year since 2011, those claims have gone up. There's at least in excess of 20,000 claims a year that employees make for discrimination and harassment. And it doesn't those claims don't necessarily have to arise during the employment process. A claim can arise even during the hiring process, before an employee is or before a candidate's even employed. So it's important for businesses to know that from the get-go, even on the employment application, they have to make sure that they're sticking to job-related questions and that they're avoiding inquiries that relate to someone's age, or you can see on this slide, marital status, pregnancy, disability, religion. And these are all issues that could come up during interviews. And it's not to say that they're always irrelevant or that there might not be a business reason for asking questions that pertain to these categories, but the business reason has to be a strong one. For example, age, that might relate to someone's physical ability, and or even more to the point, if someone has an actual physical disability, if the job requires that that person be able to have certain physical strengths, like a firefighter, for example, then obviously physical fitness might be a legitimate reason not to hire someone. If they have a disability and they can't perform a certain essential function of the job, then that could be relevant during the hiring practice. But generally it's not, and these are just definitely areas that employers need to be careful when they start to delve into these issues during the pre-screening process.
Yeah, I completely agree. In fact, we've actually done webinar debates with the OFCCP and EEOC, with whom I have very tight relationships, or we have tight relationships and friends. But the gist of it was, recruiting and hiring is all about discrimination. You discriminate about hundreds of things, just not the things on the screen.
Correct.
And as much as it made them uncomfortable to admit it, they agreed. The other thing that became very clear, and I'll share this as an experiential thing as it relates to interviewing, and I've had candidates bring up one or more of these things during the interview. And I think it's probably useful to share with the people on the call when a candidate says, well, I'm thinking about getting pregnant, or I'm, is that a problem, or I'm pregnant, or, references something about religion. It is so important to emphasize right then and there that has nothing to do with the selection, and let's go back to the items that do.
I couldn't agree more with that. I was just talking with an employer who was going through the hiring process last week, who had a candidate come in and was talking about how he could work a lot of hours, he wasn't married, and he could stay very focused at the job because he takes medication for ADD, and these were issues that came out, and I got a call, he just said these, and should we be concerned? Can we follow up? And I said, absolutely not. For a disability, for example, it's permissible to ask an employee, can you perform the functions of this job with or without some type of accommodation? Here is what you would be expected to do. You'll be expected to stand a certain number of hours, or lift a certain number of pounds, or squat, or sit, or type, or whatever. Can you perform these job duties either without any kind of an accommodation or with one? That is okay. Asking, do you have a disability that would interfere with your ability to perform the job, or will your ADD prevent you from being able to perform the job, or how often did you miss work last year? Those would be impermissible. Even following up on something a candidate just offered, like, hey, I've got ADD and I take medication, and so I can stay really focused when I'm on my medication. I think you would want to drive that back to, well, let's just focus on the function of this job, and let me explain what those are, and you tell me, can you do these functions? And if you can't, what could we do to help you perform these functions? And if you can't do them, even if we help you, then it might be permissible to make a hiring decision based on that information. But it is, again, an area where businesses have to be careful when the interview starts to go that direction.
Absolutely. Well, in the interest of time, I want to get to our last topic, which is social media and how that relates to some of the laws that are changing, and certainly it's becoming more and more pervasive every single year. You can find out almost anything about anybody, and it's readily available to all. What are your thoughts about that?
So this is becoming a bigger and bigger area for problems to arise in the employment arena. And California, not too long ago, enacted legislation in the labor code that prohibits employers from requiring that employees provide their Facebook, for example, account information so that the employer can access that and determine what's being said on social media. And it even prohibits the employer from asking an applicant or employee to sign in to his or her Facebook account or social media account so that the employer can see what is being said. And where this often arises is more and more employers are adopting or implementing social media policies in their handbooks, which attempt to prescribe rules for employees about what they can or cannot say about the business on social media. And this may be very important for companies that deal in trade secrets or confidential information, or of course want to ensure that their reputation remains good and employees aren't disparaging the business on social media. And so more and more companies are adopting social media policies that outline all these employee rules. And that's okay as long as employers aren't requiring that employees turn over their account information so that the business can then watch what's happening on that employee's social media account. Now, there are exceptions to this, like there are to almost every rule. And, the most obvious would be if there's a situation of harassment, let's just say sexual harassment, and one employee complains about another employee harassing him or her through a social media account. That might be a permissible reason for the employer then to demand that at least those posts on the social media account be turned over as part of the investigation process. That would really be probably one of the only and main reasons. And in fact, the National Labor Relations Board has really taken a strong position against how employers try to regulate social media use. And they've come out time and again and issued rulings prohibiting employers from implementing social media policies that prevent employees from basically exercising their First Amendment rights, from expressing negative feelings about a company on social media or about making negative comments about a business on social media. The NLRB has ruled time and again that that's impermissible, that those provisions in employee handbooks are basically unlawful employment practices, and the NLRB has pursued those claims, and again, those come with consequences. The NLRB has the power to order the business to revoke the policy, issue statements or post notices to employees explaining that the policy was unlawful and that it will no longer be used or implemented. There might be risk of suffering attorney's fees. Certainly having to defend against these claims is not what a business wants to do. So businesses just have to be careful in how they're regulating employee social media use, and to some extent, just general employee statements even outside of social media or discussions among employees about the company, or as I said earlier, with the Fair Pay Act, for example, employers can't really prohibit employees from discussing pay. So if they can't do it just in an in-person exchange, they also can't regulate that through social media.
That's really interesting, and the subject of perhaps our another webinar will be how
now the recruiting industry is using social media in a way that is going to almost certainly yield some legal activity, as companies like LinkedIn are now starting to predict when you're going to leave your job based on how many reviews you get or how many accolades you get and with the pace of them. And anyway, that's another whole topic.
Yeah, I could definitely see that becoming an issue and an area of law that the California legislature would be very interested in delving into, much like the legislature is not keen on allowing employers to do, credit checks. I think as social media just becomes more and more prevalent and rating systems become more and more relevant to employers, I could see the legislature definitely going in the direction of prescribing rules about the type of background searches employers can do on employees' social media accounts.
And we'll have much more interesting slides on that one too, with examples, I'm sure.
Sure.
With that, let's open it up to questions. And the page that's up, that top link will have all the resources and the presentation. So let's open it up to questions. Nicole, do we have any?
Yeah, we have a couple of questions. So let me just get those pulled up. And we'll go ahead and start working through those questions. Okay. Nope, I lost it. All right, one of the first questions that we had was, what should employers do to ensure compliance with the Fair Pay Act issues?
Sure. So I think one of the main things employers should do almost immediately is conduct a pay audit and make sure that employees who, again, are doing substantially similar work are making the same pay. And part of that process, I think, would be ensuring that the company has good job descriptions in place. And I find that businesses often do not have good, accurate, up-to-date job descriptions for their different groups or divisions of employees. And that's a problem. If you have a vague job description or it's not up to date and one job description looks very similar to another, even if in reality the jobs are very different, that could be very bad evidence if the employees with doing the actually different jobs but with similar job descriptions are getting paid differently. That would be what I would call in the litigation arena somewhat of a smoking gun and very hard to defend against. I often tell employers that having a bad policy or an inaccurate policy or a policy that's not enforced, in this case it would be a job description, is often worse than not having one at all. So making sure job descriptions are accurate and that the workforce performing substantially similar jobs is earning the same pay is, I think, key. And that just requires going through, looking at the job descriptions, looking at people's wage records. Under the California Fair Pay Act, employers keep those records for 3 years. So it's definitely worthwhile to go through that and ensure that the Fair Pay Act laws are being followed.
Hey, Shane, a couple thoughts on that and a question. The thoughts are, first of all, I think it's important to distinguish the job description for the purpose of looking in a function internally is different than what you might use to attract people for a new job, right? They don't have to be completely unrelated, but oftentimes the ones to attract someone to a new job are a little bit more focused on why you're going to Levit here and less, the 4-page document of what you're going to do in that role. Correct?
I agree. I think the latter is more marketing material. What attracts the employee, I think you definitely are geared more towards marketing. The job description for purposes of what employees are being paid and what they're expected to do at work, it can be different. I mean, you don't want them to be too different, but I wouldn't see a problem having different types of descriptions.
And the last question we have is from Isaac, about what does it mean to have dollar for dollar equality when people might have significant differences in experience even though they're in the same role, seniority, et cetera?
You know, again, that can be a factor. Their pay disparities can be justified based on bona fide factors other than gender, race, ethnicity. It's just that the employer has to reasonably account for those pay differences. Experience certainly could be a factor that justifies a pay disparity. If you have a brand new entry-level employee versus someone that's been at the company for 25 years and needs virtually no management, might be someone who generates a lot of revenue for the business, that could explain the pay disparity. But it's just important to recognize that that burden falls on the business, and you want to be able to justify those as best you can, documenting that, especially during the hiring process, I think is important, maybe by explaining in an employment offer that as a newer employee, here's the salary range for this position, and as a newer employee, you'll be making less. And this kind of actually brings me to another point, is that another amendment to the Fair Pay Act this year was that employers can no longer justify a pay disparity based on what someone earned at a prior job. So if the position at your company pays $150,000 a year, and that's what workers doing that job earn, but someone at a different company was being paid $100,000 a year and is actually even willing during the interview process to take $100,000 as their pay, even though it's less than what other workers at your business are making, that's no longer a bona fide reason for the pay disparity. So businesses can't justify the pay disparity solely on, well, he or she said that they were willing to earn less, and that's what they were making at their last job.
Shane, thank you so much. This has been enormously enlightening, and we all really appreciate your time and expertise on these items for 2017. So with that, we're going to wrap up. As I mentioned, the page you see now and the link at the top is where all the resources will be residing, and Shane's information is at the bottom. Again, Shane, thank you, and everyone have a meaningful day.
Thank you. Thank you very much, John and Nicole, for organizing this and putting it together. I really appreciate the opportunity to present today.
Absolutely, our pleasure.
Yes, thank you both, Shane and John.